Miss Davis, please start your video. Oh, we didn't. Miss Davis, you probably might need to put on a shirt, but just hold, I mean, a jacket. Just hold tight. Because, ma'am, I said hold tight. I said hold tight. I said hold tight. Okay. All right, this is case number 224454601, the people of the state of Michigan versus Shardaeus Evans. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505. I also have the complainant witness present via Zoom this morning. Ms. Davis, state your name for the court, please.
Unmute and state your name, please. Ma'am, state your name, please. She can't.
Yeah, she's unmuted. I think she's having audio issues.
Well, no, she must be because she's not even moving her mouth. Let me send a thing. She's not. I mean, she sure got up off that thing.
Janice Stevenson appearing on behalf of Mr. Shardaeus Evans. Mr. Evans, sir, please tell the judge your full name.
Shardaeus Evans.
Thank you. Ms. Ritter, you may have to call your witness. Do you have her phone number?
I do, Judge.
All right, call her. You don't have to call. I mean, you can call her and tell her to log into the next courtroom, but she needs to check her situation. So today is the date set for pretrial conference. Ms. Ritter.
Judge, I had an opportunity to speak with Ms. Davis prior to today's pretrial conference, and from my understanding,
can't hear anything.
Okay,
well,
but
we can hear you now.
But you're not gonna be able to talk though, because we can hear you. We can hear you. Okay, tell her to stop talking.
Ms. Davis.
Okay. Go ahead, Miss Ritter.
So, Judge, I had an opportunity to speak with Ms. Davis prior to today's pretrial conference, and I believe that from my understanding of the conversation, Mr. Evans is Ms. Davis's son, and the people believe this case will be best suited for the domestic violence docket.
All right. The court is going to transfer the case to the non-intimate partner domestic violence docket with Judge Austin Garrett, and Judge Baltimore said that the parties can log on now. So Mr. Evans, how did you log into my courtroom? Hey, come on.
On my phone.
No, I mean, I apologize. Let me be clearer.
I'm in the waiting room
Ma'am, you
from my phone.
You talking. If she unmute one more time, I don't know. But what I'm getting ready to remove her. Let me stop her from being able to unmute. Okay. Mr. Evans, what I meant was, did you type in my Zoom ID number, or
I can't hear you guys at all.
blessed assurance, if this baby unmute one more time? Why can't she hear you? I don't know. And why can't she unmute? Because I stopped them from being able to unmute. Okay. Did you log in using my name, or did you type in the Zoom ID?
Zoom ID.
So do you have that Zoom ID in front of you?
Yes.
Right. Look at it. Do you see the middle numbers? It says 339.
Yes.
Instead of 9, you're going to type in 8, and that's going to put you in Judge Garrett's courtroom.
All right.
They are expecting you. So go ahead, and I'm going to remove you from my Zoom, and then you can log into Judge Austin Garrett's courtroom, and they're expecting you.
Okay.
All right. Have a great day. Stay safe.
Thank you. You too.
All right. Miss Ritter, are you talking to Miss Davis?
Yes, Judge, I have Ms. Davis on the phone. She just can't hear on Zoom.
She
has
got
a device.
got that. Well, because she got that Bluetooth in that's not connected to to the thing. She needs to take out that Bluetooth, but just send her over to Judge Garrett and tell her to take that Bluetooth off because it's not working. The Bluetooth.
I
is
will,
not-
Judge.
Okay, all right.
Thank
And I'm gonna handle Mr. Forrest's case and this review, so you good for now anyway. So help her get to Judge Garrett. All right. Let me stop her video because she's not gonna even log up.
I'm
Okay.
heading back in, Judge.
Yes, you can head back in, Ms. Stevenson. Thank you.
Welcome.
Good morning, Mr. Forrest. Oh, wait, I had to change the settings because she kept unmuting. Of anger management, preferably through the EVA program. Ma'am, what you doing?
Nothing, just moving to another room.
Right, why? Because I'm in the middle of your sentencing.
I know, I hear you. I'm listening. I was just moving to another room.
Don't move to another room. Otherwise, we're gonna come in person and then we'll never have to move out of that courtroom.
Yes, ma'am.
Weeks of anger management, preferably through EVA for 3 months. If I'm satisfied with the results, then she can discontinue. So that actually means I'm going to impose $30 more on her fines, costs, and fees. So that would be $240. $30 would be for the 36th District Court urine screen. And then you shall pay all outstanding tickets that you have with the 36th District Court or get on an approved payment plan. We're going to come back to me after the 3 months so that I can see if there are any additional referrals needed, if I need to refer her to any specialty court. Based upon this misstep on page 1, I don't know, we're gonna need to confirm. Probation will need to confirm this, but it indicates that Miss McCago has 7 warrants for her arrest. She must clear up all outstanding warrants. All right, so she needs to confirm that with probation. Yes, ma'am.
Some of those are from 36. Will she be appointed a misdemeanor attorney so that she can get those taken care of? At least the ones for 36.
I see 2 for 36. Strike that. I see 1, 2, 3, 4, 5 for 36. And the answer to your question, generally speaking, is that House counsel is available to anyone in traffic courtrooms who wants to utilize them.
Thank you very much for
But
that,
she
Judge.
needs to work with her probation officer to make sure she gets a court date for those cases at 36 and then whatever else out with the other ones are out of 43rd District Court.
Thank you, Your Honor.
All right, anything further?
Nothing further from the people. Thank you, Your Honor.
But Ms. McCago, I need to let you clearly understand that when you come on Zoom, we're in court. Don't ever show back up in my courtroom with face cream on your face or walking around. We're
Yes, ma'am.
stationary, seated in an upright position, and ready to attend court at all times while
Yes,
we're
ma'am.
in court. And I would appreciate it also if you wouldn't try to interrupt me and rush me, right? Let me finish my sentences. Because if you had made a statement, I would have let you finish yours. All right, we are all set. Everybody have a great day and stay safe.
Thank you, Your Honor.
Your Honor, never mind.
She left. I mean, she
Yes.
got mad, but she got to
Fine.
and it's
No.
all right. Have a great day.
Thank
Good to see you. Stay safe.
you. Thank you, Mr. Landis.
Thank you.
All right. Versus Michael Anthony Davis. The defendant is charged with one count of malicious destruction of property. And today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Alan Applebaum on behalf of Mr. Davis.
Your P number, counsel.
36444.
And Mr. Davis, your name for the record, your full name. Unmute.
Michael Anthony Davis II.
Thank you. Today is the date set for sentencing. I've had an opportunity to review the pre-sentence report, but I think this was a case, remind me, is this the case that Mr. Smith was handling at first?
Yes, Your Honor. If the court recalls, my client took a plea in front of Judge, it was Judge King. I forgot. It's in front of, I have the transcript here, but he took a plea in front of another 36th District Court judge. At that plea hearing, Your Honor, my client had met with Mr. Marvin Smith, who was attorney at the time, and the assistant prosecutor at the time. And my client believes that they made an agreement that my client would plead guilty to the charge, immediately pay the restitution for the items that were allegedly damaged, and then probation would be immediately canceled, if that's the right word.
Yeah.
The matter transferred to you, and then at a hearing.
Okay, go ahead, counsel. I'm sorry.
At a hearing a couple of months later, my client, you had indicated that you thought that you might not give that type of sentence because you had not taken the plea and you were not part of that agreement. I had indicated that my client had indicated to me that that agreement had been placed on the record in front of the other judge. I did purchase a transcript, Judge. I do have the transcript, and that was not it was not really placed on the record.
No, it wasn't. I knew it wasn't. When he said that, I knew it wasn't, but go ahead.
I mean, basically, I can read to the court. It says here, when Mr. Davis said, I thought that this was, that was going to be the deal, the court said, all right, if I can't tell you what Judge Bryant is going to do, I can tell you what I would do in a case like this. If everything was paid off and you came for sentencing, I'd probably just close it out right then and wouldn't worry about it. So long as you can show it's paid off, your attorney can motion to have it closed out and probably will. But I can't speak for Judge Bryant, and that's where we're at. So you had indicated to my client that in theory you might, I repeat, you might allow him to withdraw his plea, but you wouldn't really make that decision until the transcript was secured and the language in that portion of the transcript provided to you. And so that's kind of where we're at, Your Honor.
Yeah. I knew that didn't happen when your client said it. Why? Because I know that my colleague who came on the bench the year before I did knows exactly how it works. So when a plea is taken in the felony courtroom, it is automatically sent to the misdemeanor court if they plead to a misdemeanor. The felony judge can only accept the plea and can never speak for the misdemeanor judge who's going to actually do the sentencing. So I knew that my colleague would not have told Mr. Davis what his sentence was going to be, because there would only be one person that knows exactly what the sentence would be, and that would be me. And then Mr. Davis's attitude was so horrible that day. I mean, it was so horrible that day. I remember it like it just happened yesterday. It was so horrible. In fact, when his lawyer came out of the breakout room, I knew that they had some strong words inside of that breakout room. And then his lawyer asked to be removed. And then Mr. Davis, he left. I think he came back, or he tried to come back or something. And his attitude was so horrible. And then I said, well, I would consider allowing him to withdraw his plea. And then I too read the transcript. And I knew that my colleagues said what he said. And Mr. Davis heard what he heard. And that's why it's a good idea to pay attention and to be cordial in court. Because then the judge comes back and remembers the attitude and behavior of the person who's asking the court to do something. And then the court is not inclined to do what the person is asking them to do because the court remembers how horrible their attitude was the first time that they came. And I don't even think that we got to even what the terms and conditions of the probation would be outside of the fact of me letting Mr. Smith know that this isn't some just pay and go. If a person maliciously destroys property, they got an anger problem. It's something else that needs to be addressed. This is a misdemeanor. And it is punishable at least by 90 days in the Wayne County Jail. And up to 2 years probation, up to $500 in fines plus costs. So, Mr. Applebaum, how did you want to proceed?
I'd like to ask Mr. Davis if he still wants to have the opportunity to withdraw his plea. I spoke to him this morning. I didn't. We wanted to see. We wanted to go to court this morning, and he's got. And I don't need, because you had indicated the last time you were not quite sure if you'd even allow him to withdraw his plea, but you didn't make a decision whether he could or couldn't at that time. I wasn't there when Mr. Smith obviously was there, and maybe Mr. Davis was, I'm not trying to make excuses, or maybe a little bit, but I think he was frustrated the last time because, right or wrong, good or bad, he was under the impression that he thought that was the deal. That doesn't make it right. That just means what was in his mind. So I think he was a little bit frustrated with Mr. Smith and or whoever, or maybe he should be frustrated at himself. That I understand.
For not listening when Judge King clearly said, I can't tell you what Judge Bryant is going to do. I could tell you what I would do. And then that's why when he was on this docket, he was doing what he was doing. And then he wanted to be on felonies and I wanted to be on here, and we switched places. And now he can't tell me what to do and I can't tell him what to do. And that's why we're right here, right there.
But I wanted to get that transcript to show him, and he's absolutely read that transcript. So he knows. Okay. He understands.
All right.
So the question, Mr. Davis, is, and I've not seen the pre-sentence report, Your Honor, but Mr. Davis, do you want to go ahead with sentencing with Judge Bryant? Do you want to respectfully ask to withdraw your plea, have the felony charge reinstated, then back to the drawing board? That's, we've talked about it. So you got to make a big decision.
Okay, Miss Bryant, Miss Judge Bryant. With all due respect, I apologize for being rude. I just felt like I was getting shambled by my former attorney, because what he took me out in the hallway and talked to the prosecutor about, yes, you're right, it wasn't put on record. But they clearly took me out in the hallway and say, take this plea and just pay this money, and I'm not going to look forward to moving forward and pressing any charges. And then go downstairs, pay the $1,200, and then everything will go away. And then so when the judge got to talking and then it got shifted, that's when I got upset. I wouldn't get upset about nothing else. I mean, I was mad.
Seemed to me like that would have been the appropriate time to ask Judge King to withdraw the plea. Seemed to me like that's why you say, has anyone promised you anything that was not placed on the record in order to get you to make the plea? But your anger was misplaced and it was misdirected and it was rude and it was disrespectful.
Okay.
And having read the transcript, I don't believe that the option of withdrawing the plea is an option. Judge King was clear. Judge King was clear, unequivocally. He said, I can only tell you what I would do.
Okay, and then also, Judge, I want like they sent the papers in the transcript, and they sent the papers downstairs for me to go pay. And also, Mrs. Smith filed a motion like a week later.
Couldn't have sent no papers downstairs for you to pay because Judge King cannot impose any sentence. So there was no sentencing. There was no sentencing. Let's be clear. There was no sentencing.
I understand that, but it's in the transcript saying that we are sending the papers downstairs for me to go pay. I stayed downstairs for an hour and the papers never came. I was at the window.
Well, there is some language, Your Honor, in the transcript regarding some paperwork going down to the probation department. But I think that-
Probation, a referral to probation
I,
for a pre-sentence
I,
investigation.
I agree with that. That's what I
Oh.
believe.
Oh, man.
So I
Judge,
don't,
I
I
don't have to
don't
read them.
think there's any language in the transcript that talks about the agreement. I'm just trying to see here. Whether, you know, there's standard statements that are made before a plea is taken regarding promises and things like that. And it says, you know, do you understand the rights? And you had an opportunity to talk to your attorney, and then you're waiving your rights. That was the standard thing. Anything regarding a promise of the sentencing, but I don't, let's see here. You're giving up your rights. You have a right to be presumed innocent. He goes through the standard subpoena powers. So I don't think there's any language in that transcript regarding whether any promises were made, though when they got to the last paragraph on the last page of the transcript, Judge King specifically says, you know, this is what I would do, but I'm not Judge Bryant, and she's got to make her own decision. And never was given an opportunity after that statement. It just went right to, okay, you're sentenced, you'll get your sentencing date and be on your way. So there's some frustration on his part, justified or unjustified, as to the procedure of what happened. But that's kind of where we're at, Your Honor.
Well, it's my decision is that I'm not going to allow the withdrawing of the plea.
Then, Your Honor, I haven't had a chance to see the probation report, but so I don't know what the recommendation is. I don't know if you want to give the people a chance to send that to me, whether you can give me the highlights over the phone so I can elocute on his behalf. But I did not get an email or anything in the mail regarding a proposed pre-sentence report. Now, maybe it was given to Mr. Smith, but I have filed an appearance in this case.
It probably was. The pre-sentence investigation is dated April the 12th, 2023. So it is the original pre-sentence report. We can send it to you and I can adjourn the sentencing, give you opportunity to go over it with your client. It's a standard recommendation. In fact, it's a little surprising to me of the recommendation for 12 months probation, since Mr. Davis has a previous conviction for aggravated assault. But nonetheless, well, I guess that's not a conviction. It's not.
Yes, Judge, is that probation reporting or non-reporting?
Oh, all of my probations are usually reporting, depending on what I order. There is a recommendation for anger management. And because of the way that Mr. Davis always acts when he comes to my courtroom, he definitely needs anger management. So there is a recommendation for anger management.
I hope he's presenting himself professionally this morning, Your Honor. He hasn't raised his voice. He hasn't seemed too frustrated. I think he's been.
I fashion myself a body language expert. That's a part of what I'm gonna do when I leave the bench. And every time I say something that he don't like, I'm from the east side too, 6115 Seneca. Every time I say something he don't like, he rolls his eyes, he grunts, his nose inflects out, his mouth. I'm gonna make money helping people pick juries because I'm gonna watch the body language of the jurors. I fashion myself to be very insightful in that area. So no, he has not yelled and raised his voice today. No, he has not exhibited the behavior that he exhibited before. But it is clear to me that for whatever reason and whatever occurred between Mr. Davis and Mr. Smith, number one, he's not over it. But had he gone into the courtroom with Judge King and actually paid attention to what the judge was saying, we probably wouldn't have all this anger and stuff right now. But there is a recommendation for anger management. Now, there was a recommendation in my previous case for anger management. And then I said, well, I'm going to focus more on this area. So, Madam Prosecutor, is there any objection to me reducing that anger management? And then she said, no objection. Because that's the kind of judge I am. I'm a judge who believes in an individualized sentencing, right? I'm a judge that believes in looking at the circumstances and deciding the sentencing. But from what I see from your client, that recommendation for 12 months, 12 weeks of anger management, it almost should be 24 weeks. That's what I see. But I probably wouldn't do that, but that's what I see.
So, Mr. Davis, you've kind of got an idea of what there's obviously there appears to be no recommendation of incarceration. Looks like 12 months reporting probation. There's going to be some weeks of possibly of anger management. Do you want to go into a breakout room? Or are you ready to proceed to sentencing? Because you're going to the recommendation is not going to change, whether we delay it or not. And I think
it don't matter. I mean, Judge, listen, I didn't want you to take nothing the wrong way, this, that, and the other, but
No, these comments are not, these
I
comments.
have been through so much. I'm from the east side of 6 Mile Grass here.
Sir, can you hear me? Am I muted? Am I muted?
Oh, let me see. Oh.
No, I'm not muted. So at this point, I only want to know, are we proceeding with the sentencing today? And if we are, then Mr. Davis will get an opportunity to speak. But right now,
Oh, I didn't know that.
only issue
No.
is, are we proceeding today? Because I've been through a
No.
lot too. Yesterday was the anniversary of my sister's death, who died young after she suffered a stroke. I've been through a lot too.
Yeah.
They thought I had breast cancer. I've been through a lot too.
Right.
I was homeless. I've been through a lot too. We all been through a lot.
Yeah.
We don't come in here and take out our frustrations on the people who've done nothing to you. No, that's not how it works.
Right.
Now, I've been real patient. So counsel, I'm gonna send you and your client to a breakout room. Then he could tell you if he wants you to go over the report in detail. I will give you an adjournment if you request it, because we did send it to Mr. Smith, and I'm sure Mr. Smith, perhaps he didn't forward it to you. So let's send you both to breakout room number 3.
I think Mr. Davis can answer that question.
Oh, okay. Well, because let me tell you another observation. Remember, I said I was observing, and this what and so there's a judge sitting in my office because she's going to help with my docket next week. So she had come in to just kind of watch and then so I go over the docket with her. She just came in after we started, and she got the same feeling about Mr. Davis that I have. She said she from the east side too. She recognized all that aggression too. It's a lot of aggression going on with Mr. Davis. And so maybe he might want to wait, but I know how to separate. So are we going to sentencing today, or am I giving an adjournment?
Mike, you want to go ahead right now, or you want to get an adjournment?
No, please, let's adjourn it.
Okay.
No, so yeah. Yeah. Can
All
we
right.
adjourn it, please?
We're going to adjourn to also, is 23rd a good day for you?
It is a good day. All I have is a 10:30 in probate court. But
Oh,
I'm
wait,
good.
I apologize. Not the 23rd. Excuse me. No, I can't do the 23rd. The 25th, the Friday.
That's fine.
Okay, I can adjourn it to the 25th of August.
What time, Your Honor?
9 o'clock.
And what would be the procedure, if any, Your Honor, for me to get that report? Should I come down to the courthouse to physically?
Oh, no, you don't have to do that. If you could put your email in the chat, or if you could just call the courtroom, Mr. Flanagan will email you the report. Okay, then everybody have a great day and stay safe.
Okay, you too.
All right. Bye now.